Welcome to a special NatSecMedia presentation of the United States versus Donald John Trump, the special counsel for the United States Department of Justice since 2022, filing by Jack Smith titled, Government's Motion for Immunity Determinations. Submitted to the court on October 2, 2024. The 165-page filing answers the questions created by the Supreme Court, ruling on presidential powers and official acts. As you will hear, the special counsel demonstrates these crimes were not official acts. Take the time to explore each section and consider the overwhelming evidence against the former president, now convicted felon, and his associates. Thank you for listening. NatSecMedia is non-commercial programming supported directly by our listeners and viewers. This is the special counsel for the United States Department of Justice Jack Smith's filing, titled, Government's Motion for Immunity Determinations. The defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because, he claims, it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, the defendant acted as a candidate when he pursued multiple criminal means to disrupt, through fraud and deceit, the government function by which votes are collected and counted, a function in which the defendant, as president, had no official role. In Trump v. United States, the Supreme Court held that presidents are immune from prosecution for certain official conduct, including the defendant's use of the Justice Department in furtherance of his scheme, as was alleged in the original indictment, and remanded to this court to determine whether the remaining allegations against the defendant are immunized. The answer to that question is no. This motion provides a comprehensive account of the defendant's private criminal conduct, sets forth the legal framework created by Trump for resolving immunity claims, applies that framework to establish that none of the defendant's charged conduct is immunized because it either was unofficial or any presumptive immunity is rebutted, and requests the relief the government seeks, which is, at bottom, this: that the court determine that the defendant must stand trial for his private crimes, as would any other citizen. This motion provides the framework for conducting the necessarily fact-bound immunity analysis required by the Supreme Court's remand order. It proceeds in 4 parts. Section 1 provides a detailed statement of the case that the government intends to prove at trial. This includes the conduct alleged in the superseding indictment, as well as other categories of evidence that the government intends to present in its case in chief. This detailed statement reflects the Supreme Court's ruling that presidential immunity contains an evidentiary component, which should be addressed at the outset of a proceeding. Section 2 sets forth the legal principles governing claims of presidential immunity. It explains that, for each category of conduct that the Supreme Court has not yet addressed, this court should first determine whether it was official or unofficial by analyzing the relevant content, form, and context ID at 2340 to determine whether the defendant was acting in his official capacity or instead in his capacity as a candidate for re-election. Where the defendant was acting as office seeker, not office holder, no immunity attaches. For any conduct deemed official, the court should next determine whether the presumption of immunity is rebutted, which requires the government to show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Section 3 then applies those legal principles to the defendant's conduct and establishes that nothing the government intends to present to the jury is protected by presidential immunity. Although the defendant's discussions with the vice president about their official responsibilities qualify as official, the government rebuts the presumption of immunity, and all of the defendant's remaining conduct was unofficial. As content, form, and context show, the defendant was acting in his capacity as a candidate for re-election, not in his capacity as president. In the alternative, if any of this conduct were deemed official, the government could rebut the presumption of immunity. Finally, Section 4 explains the relief sought by the government and specifies the findings the court should make in a single order, namely, that the defendant's conduct set forth in Section 1 is not immunized, and that, as a result, the defendant must stand trial on the superseding indictment, and the government is not prohibited at trial from using evidence of the conduct described in Section 1.
Section 1. Factual Proffer.
When the defendant lost the 2020 presidential election, he resorted to crimes to try to stay in office. With private co-conspirators, the defendant launched a series of increasingly desperate plans to overturn the legitimate election results in 7 states that he had lost: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, the targeted states. His efforts included lying to state officials in order to induce them to ignore true vote counts, manufacturing fraudulent electoral votes in the targeted states, attempting to enlist Vice President Michael R. Pence, in his role as President of the Senate, to obstruct Congress's certification of the election by using the defendant's fraudulent electoral votes, and when all else had failed, on January 6, 2021, directing an angry crowd of supporters to the United States Capitol to obstruct the congressional certification. The through line of these efforts was deceit, the defendants and co-conspirators' knowingly false claims of election fraud. They used these lies in furtherance of 3 conspiracies. 1. A conspiracy to interfere with the federal government function by which the nation collects and counts election results, which is set forth in the Constitution and the Electoral Count Act, ECA. 2. A conspiracy to obstruct the official proceeding in which Congress certifies the legitimate results of the presidential election. And 3. A conspiracy against the rights of millions of Americans to vote and have their votes counted. At its core, the defendant's scheme was a private criminal effort. In his capacity as a candidate, the defendant used deceit to target every stage of the electoral process, which through the Constitution, ECA, and state laws, includes the state's notification to the federal government of the selection of their representative electors based on the popular vote in the state. The meeting of those electors to cast their votes consistent with the popular vote, and Congress's counting of the electors' votes at a certification proceeding. As set forth in detail below, the defendant worked with private co-conspirators, including private attorneys Rudy Giuliani, John Eastman, Sidney Powell, and Ken Cheeseborough, and private political operatives Boris Epstein and Steve Bannon. The defendant also relied heavily on private agents, such as his campaign employees and volunteers, like campaign manager Bill Stepien, deputy campaign manager Justin Clark, senior campaign advisor Jason Miller, and campaign operative Mike Roman. In this section, the government sets forth detailed facts supporting the charges against the defendant, before addressing in the next section why none of this conduct is subject to immunity under the Supreme Court's decision in Trump. The conduct set forth below includes the defendant's formation of the conspiracies leading up to and immediately following the 2020 presidential election, certain information regarding his knowledge that there had not been outcome-determinative fraud in the election as he persistently claimed, and his increasingly desperate efforts to use knowingly false claims of election fraud to disrupt the electoral process. The government does not consider any of the following conduct to be subject to immunity, for the reasons set forth in Section 3.
A. Formation of the conspiracies.
Although his multiple conspiracies began after Election Day in 2020, the defendant laid the groundwork for his crimes well before then. Leading into the election, the defendant's private and campaign advisors, including Person 6, then a private citizen, and Bill Stepien, the defendant's campaign manager, informed him that it would be a close contest and that it was unlikely to be finalized on Election Day, in part because of the time needed to process large numbers of mail-in ballots prompted by the COVID-19 pandemic. They also told the defendant that the initial returns on election night might be misleading, that is, that he might take an early lead in the vote count that would diminish as mail-in ballots were counted because his own supporters favored in-person voting, while supporters of his opponent, Joseph R. Biden, favored mail-in ballots. Privately, the defendant told advisors including Person 6 campaign personnel, Person 7, a White House staffer and campaign volunteer, and Mark Short, the vice president's chief of staff, that in such a scenario, he would simply declare victory before all the ballots were counted and any winner was projected. Publicly, the defendant began to plant the seeds for that false declaration. In the months leading up to the election, he refused to say whether he would accept the election results, insisted that he could lose the election only because of fraud, falsely claimed that mail-in ballots were inherently fraudulent, and asserted that only votes counted by Election Day were valid. For instance, in an interview on July 19, 2020, when asked repeatedly if he would accept the results of the election, the defendant said he would have to see, and it depends. On July 30th, despite having voted by mail himself earlier that year, the defendant suggested that widespread mail-in voting provided cause for delaying the election, tweeting, "With universal mail-in voting, not absentee voting, which is good. 2020 will be the most inaccurate and fraudulent election in history. It will be a great embarrassment to the USA. Delay the election until people can properly, securely, and safely vote." In an interview on August 2nd, the defendant claimed without any basis that there is no way you can go through a mail-in vote without massive cheating. At a campaign event in Wisconsin on August 17th, the defendant told his supporters, "The only way we're going to lose this election is if the election is rigged. Remember that. It's the only way we're going to lose this election, so we have to be very careful." In his acceptance speech at the Republican National Convention on August 24th, the defendant said that the only way they can take this election away from us is if this is a rigged election. On October 27th, during remarks regarding his campaign, the defendant said, "It would be very, very proper and very nice if a winner were declared on November 3rd, instead of counting ballots for 2 weeks, which is totally inappropriate, and I don't believe that that's by our laws. I don't believe that. So we'll see what happens." The defendant said this despite, or perhaps because, his private advisors had informed him that it was unlikely that the winner of the election would be declared on November 3rd. By October 2020, Steve Bannon, a private political advisor who had worked for the defendant's 2016 presidential campaign, began to assist with the defendant's re-election effort. 3 days before Election Day, Steve Bannon described the defendant's plan to a private gathering of supporters. And what Trump's going to do is just declare victory, right? He's going to declare victory. That doesn't mean he's the winner. He's just going to say he's the winner. After explaining that Biden's supporters favored voting by mail, Steve Bannon stated further, "And so they're going to have a natural disadvantage, and Trump's going to take advantage of it. That's our strategy. He's going to declare himself a winner." Immediately following Election Day on November 3rd, the defendant did exactly that. As his private and campaign advisors had predicted to him, in certain states, the defendant took an early lead on Election Day that began to erode. At approximately 11:20 p.m., Fox News projected that Biden would prevail in the state of Arizona, and according to campaign advisor Jason Miller, he and the defendant were shocked and angry at this development. As Election Day turned to November 4th, the contest was too close to project a winner, and in discussions about what the defendant should say publicly regarding the election, senior advisors suggested that the defendant should show restraint while counting continued. 2 private advisors, however, advocated a different course. Giuliani and Boris Epstein suggested that the defendant just declare victory, and at about 2:20 a.m., the defendant gave televised remarks to a crowd of his campaign supporters in which he falsely claimed, without evidence or specificity, that there had been fraud in the election and that he had won. This is a fraud on the American public. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election. In the immediate post-election period, while the defendant claimed fraud without proof, his private operatives sought to create chaos rather than seek clarity at polling places where states were continuing to tabulate votes. For example, on November 4th, Mike Roman, a campaign employee, agent, and co-conspirator of the defendant, tried to sow confusion when the ongoing vote count at the TCF Center in Detroit, Michigan, looked unfavorable for the defendant. There, when a colleague at the TCF Center told Mike Roman, "We think a batch of votes heavily in Biden's favor is right," Mike Roman responded, "Find a reason it isn't. Give me options to file litigation, and even if it is." When the colleague suggested that there was about to be unrest reminiscent of the Brooks Brothers riot, a violent effort to stop the vote count in Florida after the 2000 presidential election, Mike Roman responded, "Make them riot and do it." The defendant's campaign operatives and supporters used similar tactics at other tabulation centers, including in Philadelphia, Pennsylvania, and the defendant sometimes used the resulting confrontations to falsely claim that his election observers were being denied proper access, thus serving as a predicate to the defendant's claim that fraud must have occurred in the observer's absence. Contrary to the defendant's public claims of victory immediately following Election Day, his advisors informed him that he would likely lose. On November 7th, in a private campaign meeting that included Bill Stepien, Justin Clark, Jason Miller, and White House staffer Eric Hirschman, who came to serve as a conduit for information from the campaign to the defendant, campaign staff told the defendant that he had only a slim chance of prevailing in the election and that any potential success was contingent on the defendant winning all ongoing vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that assessment, on November 13th, the defendant's campaign conceded its litigation in Arizona, meaning that based on his campaign advisor's previous assessment, the defendant had lost the election. That same day, in an implicit acknowledgement that he had no lawful way to prevail, the defendant sidelined the existing campaign staff responsible for mounting his legal election challenges. From Bill Stepien, Justin Clark, and others who were telling the defendant the truth that he did not want to hear, that he had lost, the defendant turned to Giuliani, a private attorney who was willing to falsely claim victory and spread knowingly false claims of election fraud. As the defendant placed alternating phone calls to Justin Clark and Giuliani throughout November 13th, Steve Bannon informed Boris Epstein, another private campaign advisor, of the change, writing, "Close hold, don't tell anyone. Trump just fired Justin Clark and put Giuliani in charge, and you are to report to Giuliani." When Boris Epstein asked if Bill Stepien was gone too, Steve Bannon replied that they all report to Giuliani and that Steve Bannon had made a recommendation directly that if Giuliani was not in charge, this thing is over. Trump is into the end. The next day, consistent with Steve Bannon's description, the defendant announced his staff change by tweet, writing, "I look forward Giuliani spearheading the legal effort to defend our right to free and fair elections. Giuliani, Joseph DiGenova, Victoria Twenzing, Sidney Powell, and Jenna Ellis to a truly great team, added to our other wonderful lawyers and representatives."
You've been listening to part 1 of our presentation of the United States versus Donald J. Trump filing, titled Government's Motion for Immunity Determinations. Stay tuned for part 2. The defendant knew that his claims of outcome, determinative fraud, were false. NatSecMedia is non-commercial programming, supported by listeners and viewers like you. Subscribe below to stay tuned to our next video. Consider subscribing on Patreon at NatSecMedia. Thank you.